Hi, everyone. It's really great having you here. We're going to be discussing today informed consent disclosure and record keeping so that you're not repeating your script every time.
These ones are, so we've written 5 different ones.
Oh, okay. Apologies. See my lack of information. Okay.
Yeah. Perfect. If you pop it on the screen, I'll be good to go when you guys are ready.
Brad, can you go back a little bit again? Sorry. Yeah, and then just bring your laptop. It feels like it's moved. Yeah, and just bring your laptop screen down a bit towards you. There we go.
Is that better? Is that better for you?
Yes, thank you. Happy with that?
Okay.
There we go. In this kind of a situation, the further away you are, the better, Brad.
Okay. Let me just work on that a bit. How much further back than this do you want me?
That's cool. And then just turn your screen down towards you a teeny bit. There we go. Okay.
More than that?
Yeah, perfect. We're happy with that. Thank you, Brad.
Okay, I'll try and sit like this for the next hour.
Perfect. Don't budge.
Yeah, that can be done.
Yeah, I'm just making sure. Okay. Okay, guys. So stand by. We're going to go for it in a second. Here we go. Enjoy it all yours when you're ready.
Good day, doctors. Thank you for taking the time out of your busy schedule to join this Genoa Underwriting Management CPD event. I'm Michael John Demant, and I'm a director of Genoa. Genoa, as many of you may know, is not your typical insurer in that we focus entirely on offering professional indemnity solutions to the professional market. Our management team has been doing this for decades and are recognized as experts in our field. We've built up a proven track record as we take care of the insurance needs of over 4,200 attorneys, the top business rescue practitioners in the country, and of course, the sizable pool of select medical practitioners that include some of you listening to this talk. I have the pleasure of introducing Dr. Byra, who will be discussing informed consent. Dr. Byra is an accomplished speaker who has spoken all around the world on medico-legal matters, and we're very proud to have him in the Genoa team. Enjoy the presentation, and over to you, Brad.
Thank you, Michael John, and hello to everyone. Today we're going to be talking about informed consent disclosure and record keeping. We're going to talk about it in terms of the requirements that we have in doing informed consent and in managing disclosure and in keeping records as laid out by the Health Professions Council. We're also going to look at it in terms of the implications that it has in terms of patient safety. We're going to look at it in terms of the impact that a lack of informed consent or poor disclosure or record keeping may have on your practice in the event that you end up in a dispute with your patient. We're going to spend the next 50 to 55 minutes going through this, and I hope that this is a reflective and introspective piece of work for you. As we kick off and we look at medical professional indemnity, we need to recognize a couple of things about the world that we live in. We, as registered professionals, are human. And because we're human, there are times where we make a mistake. And mistakes are part of a level of reasonableness of care. And that reasonableness of care recognizes the fact that as individuals, we are all different from each other. So I recall recently doing a piece of work where a surgeon is going through a laparoscopic investigation, and they use the phrase, and this is an example of what typical anatomy might look like. Now, typical anatomy means that at least 4 out of 10 persons would have anatomy the same or similar, which means that 6 out of 10 may have anatomy, 3 of the 6 being significantly atypical on the one side, being highly unusual, and 3 on the other side being highly unusual. So 6 out of 10 on any Gaussian curve fall outside of the normal. And so outside of the normal when it comes to people is a very real challenge that we face in terms of how we manage our communications with our patients. So if we pause for a minute and we look at this and we say, out of every 100 consultations, you have up to 25%, so 1 in 24 patient safety incidents per 100 consultations. Well, what does that mean? It means that there is the risk of an adverse outcome for the patient. There is a risk of a complication, or there is a risk that the treatment that we give results in a patient experience that is not comfortable for the patient, that could have near or long-lasting health impacts for them. So that's the circumstance that we work under here. And we can bear in mind that when we work under this, adverse outcomes as a result of medical care result to the 14th largest cause of morbidity and mortality in the healthcare world, equating in an equivalency term to that being the same as tuberculosis or malaria impact. So when we start going down this journey, and part of today's conversation is to encourage you to be reflective of how you manage your practice in terms of your communications with your patient. So we get a couple of errors that happen. There's an error by commission, and that is an error because of something that one does. A medication error could be an error of commission. You might do a surgical procedure or a small procedure in your rooms where your hand is not as steady as it might be, or you cut deeper than you thought, or you cut more laterally than you thought, or your suture isn't as clean as you thought, and it results either in a complication or there's a sepsis as a complication that comes out of that. Those would be regarded as errors by commission, errors of things that one's done. Then you have an error by omission. And an error by omission is things that you failed to do or tasks that you've left undone. And that could be a missed care that you've elected not to do. It could be a gap in care. It could be a question that you didn't ask. And I say this because when I started in my first case history I did in 1991. And the case history took me nearly an hour as an undergraduate. I had all of these questions that I needed to ask, and then I needed to go and see my clinician in charge, and I needed to ask the questions. Then I went back to the patient, then I went back to the clinician, because it was a long journey as an undergraduate. And that was my first case history. Nowadays, I don't think people generally take anywhere near that amount of time in a case history with a patient. What's the risk? The risk is you might have left something out. You might not have asked the right question. You might not have spent enough time sharing the risk of a complication with a patient. Those are errors by omission. And both of those, errors by commission and errors by omission, lead to lapses in the quality of care that we have with patients. So the journey that we're going to go through today, which is to talk about informed consent and to talk about disclosure and to talk about record keeping, is to try and bring closer to our minds the importance of taking a systematic, progressive approach to how we manage our experience with our patient. There's a beautiful statement, and we could share this on a different day, where the patient writes to the doctor, and the patient says, please understand in terms of my journey as a patient, that you are seeing many patients in a day, but you are the only doctor that I'm seeing. Take the time to listen to me. Take the time to hear me. Be gentle with the fact that I'm nervous and feel out of control. Now, we don't always bear that in mind. And we also recognize that there are times where the patient doesn't fully disclose, either because we haven't taken them through the journey of conversation properly in our case history, or we haven't given them the right information for them to understand what's relevant, or sometimes because they elect not to share with us. Now, regardless of which of those facts it is, we as practitioners still have to act in a manner that allows us to be able to reproduce and record what we've done, what we've said, who we've spoken with, and how we've come to the decisions that we've come to in terms of the treatment that we give. So when we look at informed consent is a process of getting permission before conducting a healthcare intervention. Now, that healthcare intervention could be the general discussion with your patient. It could be the procedure that you do. It could be the medicines that you give. It's also before disclosing personal information about that patient to any other person. Now, consent in its own right is an expression of will by any person. We're going to talk about this a lot in terms of what the law says we can and can't do. But it's important to know at this point that a healthcare practitioner may ask a patient to consent to receive therapy before providing. It's the same as a clinical researcher may ask a research participant before enrolling that person into a clinical trial for their permission. But a healthcare practitioner may not provide the intervention without the consent of that patient. And there's implications to that, and we'll talk about that. Informed consent is collected in terms of the guidelines in the field of medical ethics and research ethics, and we're going to talk about the Health Professions Council of South Africa ethical guidelines and which booklets you need to be specifically mindful of for informed consent, for record keeping, and for disclosure. And we're going to start by talking about the National Health Act, which makes it an offense to provide a health service to a user. And a user is any patient, whether they're a minor or somebody who is in the majority, whether they're a mental health user, whether they've got capacity or not. It's an offense to provide a healthcare service to a user without their informed consent. Now, recently, there's been a lot published, and you will have heard about the Protection of Personal Information Act here, called POPI. And in the European Union, you would have heard about the General Data Protection Regulations, and you'll have heard in the US about HIPAA. These are all different acts in the different countries, making sure that we protect the patient's information properly and that the patient has access to their information. And recently, the phrase called meaningful consent was introduced. Now, a meaningful consent needs to tick 4 specific boxes or meet 4 criteria. The first one is, what personal information am I collecting? So what patient information am I collecting from you as the person, and to whom will I share this information? Now, in our practices, we would have to bear in mind, we may be required to share this information with a payer or a funder. There's ICD information, which is the International Classification of Disease Coding information that needs to be shared. We may be required to share this with other healthcare practitioners, both primary, secondary, and tertiary. We then need to know for what purposes is the information being collected, used, or disclosed. So we're collecting this information for the purpose of understanding what your health history is, with the purpose of understanding what you may need, and so that we can decide what best care to provide for you, both in terms of this practice and broader, would be part of your meaningful consent. And then what, if any, are the risks of harm or other consequences of me collecting this information and providing it to you? And that combination of 4 steps, what personal information is being collected, who are we sharing it with, for what purpose is it being collected, and what is the harm of it being collected, are part of the consent process that you need to be able to share with the patient. So informed consent is more than just the process of getting permission. It's along the journey or the patient experience. So this is a story shared with permission from Dr. Mark. Dr. Mark was seeing a patient. The patient took a position which turned out to be a frivolous position. In other words, it didn't have merit, but our practitioner spent 2 weeks in court giving evidence. There was his feeling, which he said, he felt completely alone. He didn't have collegial support until after the trial was over and he was exonerated. Only at that point did he get feedback from his colleagues saying, "Oh, we supported you. We really appreciated what you did. We thought you were completely right." But during his journey, and we're not here to talk about the journey of medical litigation today, during his journey, he felt like he didn't have collegial support. And he learned 2 things that came out of this. And these were the 2 messages that he shared. that the informed consent is the entire patient-doctor experience. It's not simply the experience of the form. It's the experience that the patient has with you from the minute that that patient walks into your rooms to the time that the treatment and its related recovery is entirely complete. It's the conversation you have, it's the environment that you've set, it's the clarity of information that you've shared, it's your testing and probing to understand that the patient understands what you're saying. And then it's the physical recording in writing, where necessary, of the permissions given to you by that patient to do what needs to be done. It also relates to the expectations that the patient has of how they will feel after the end of the treatment, because there is a reality, and that reality is that your expectation of the treatment and your patient's expectation of the treatment may be completely different. You may, in your experience and your expertise, know that at the end of the intervention, you will have removed the cause of the pain, but healing is still needed to happen. The patient may wake up post-procedure or post-treatment and expect to be 100% return to function. That gap of expectation needs to be recorded in your informed consent. And then the second piece that came out, and this is something for you to think about, is one needs to recognize that the process of providing care to another person is stressful. And when there is an adverse outcome, or when one works in an adverse environment like a high stress situation, and a high stress situation could be a high patient volume, it could be with patients who have a low therapeutic outcome or a reduced risk of full recovery. It could be working in a circumstance like the COVID-19 circumstance, where the thorough examination of the patient is difficult to do, but one needs to recognize that there is a risk of post-traumatic stress disorder for you as the practitioner. And recognizing that and how you manage that is a very important outcome of your patient experience. And your patient experience is how you run your practice and how you're experiencing your therapeutic consultation. So when we consider consent, informed consent is broad, and it addresses a couple of things. It addresses what therapy you believe is best for the patient. It addresses the alternative therapies that that patient may or may not consider, each with its own benefits, each with its own harm, and each with its own potential risks. So guiding your patient through the best decisions sits within a couple of different ethical and moral obligations that you have. And I was introduced to a concept the other day called the ESLI concept. There are ethical, social, and legal implications to all of the advice that you offer and all of the interventions that you give. But to guide you, I would suggest that it's worthwhile downloading the Health Professions Council from South Africa's ethical guidelines booklets. There are, you can download them all into a single PDF file. It's 334 odd pages, and all of the booklets are contained there. And the reason that I suggest that is all of the content that we're discussing today and all of the guidance notes that you need in order to ethically, socially, and legally appropriately manage your patients and your communication with them are captured in these booklets. So the Health Professions Council in booklet 1 in section 4.6 speaks about the natural duties and moral obligations, plus the institutional duties and legal duties that you have as a practitioner in supporting your patient. In that same booklet, in section 5.3.4, they talk about the importance of the principle of informed consent as an ongoing process, which then speaks with booklet 4, which is around the importance of seeking informed consent. Now, those two components together, recognizing that informed consent isn't once off. It's not a blanket consent that you can give once. It is iterative. And each time you introduce a new procedure, or each time you are treating that patient for potentially a different condition, you need to go through the consent process again. And part of that consent process is you need to talk about the details of their condition. You need to talk about the details of the investigations and the treatment options. And you need to, which people often don't do, talk about the costs. When we've looked historically at some of the reasons that a patient takes a position of dispute against the practitioner, it's not about the details of the condition or the outcome or the secondary infection or the pain. It's often that they receive a bill or they didn't realize what the cost implications were going to be. And only once they've received your invoice do they then stop seeing the social merits and start looking at legal recourse against one. So bear in mind that those three considerations need to be done. So my question to you at this point would be, if you were to look at your informed consent checklist, now I'm assuming that you have an informed consent checklist, and if you don't, you may want to have an informed consent checklist that says, have I shared the details of this patient's current condition with them? Have I shared the details of the investigations and tests that I want to do? Have I shared the details of the treatment options that I need to share? And does the patient understand the costs? And those costs would also potentially be the costs directly to them, the costs that may or may not be borne by a third-party payer, and the shortfall that they may be liable for. So consent is broad in that sense. And often, when we start looking at this in terms of that first slide, when I started speaking about errors by omission, things that we've left out, we may not have given all the details of the condition. We may not have given all the details of the investigation. And we may not have given all of the treatment options. Oftentimes, because we don't always know it, we may not give the details of the costs. And part of that may be to say that the costs that you are going to get from me are not all of the costs that relate to this treatment. They only relate to the costs of my own expenses. Your hospital costs, if you're the surgeon, the anesthesiology costs, the costs of materials used are all separate from my costs. So you need to have some form of mechanism to help a patient understand what it is that they are giving you permission for. So let's define informed consent. And let's define it in terms of both the dictionary definition and a couple of criteria. So the first criteria is to inform somebody is to tell them about specific facts. And the consent is that they will agree to allow to have somebody do something to them based on the facts that they've been given. So under Black's Law Directory, a patient's knowing a choice on a medical treatment or procedure made after the physician or other healthcare provider discloses whatever information a reasonably prudent provider in the medical community would give to a patient regarding the risks involved in the proposed treatment or procedure. Now, there's some key words there as I've read that out to you. It's the patient's knowing choice. The patient's knowing choice means that they need to be able to feed back to you what it is you've said to them in their own language, and we're going to talk about that a bit later. The second piece there is around the provider discloses. In other words, you need to be able to share information with them in that accessible way. And then the third piece there that I'd like you to be mindful of is the reasonably prudent provider. And what that means is it needs to pass the reasonable person test. You cannot be expected to give every item of every piece of information, but you need to be able to follow that test that says, what would you be reasonably expected to hear if you were on the recipient end? And what would a colleague of yours reasonably give if it wasn't you? So bearing that in mind, we go back to the doctrine that you'll see there, and that is to a willing person, injury is not done. So the treatment that you're needing to give needs to be recognized by law. It can't be against good morals. You can't be offering to do something that is against the laws of the land. The permission needs to be given by the person capable in law of giving that permission. In other words, they need to be able to have intention and understanding, and it needs to be free and voluntary. That consent needs to both acknowledge the knowledge and awareness of the nature and extent of the harm, and the appreciation and understanding of the nature and extent of harm. So it's not enough just to know what the nature of the risk could be. You also have to appreciate the impact of that risk and understand the impact that that'll have on one's body and one's life. You have to then consent to that harm or that risk. It's not only the consent to the procedure, it's the consent to knowing that the procedure could lead to harm, and you're accepting that that outcome could happen, that that complication could happen, that that limitation or loss of function could happen. The consent must be comprehensive. It must go through the entire transaction. As we spoke about in the previous slide, it needs to go through the condition, the investigations, the treatments, and the costs, and it needs to be inclusive of the consequences, of the outcomes that could be less desirable or undesirable. The consent needs to be clear, it needs to be unequivocal, and it needs to relate to the activity or the conduct in question. It needs to be manifested externally, and what that means is it needs to be written down and or recorded in a way that's permanently reproducible. It can't be, do you agree, asks the practitioner, and the patient nods, and that's regarded as consent. It needs to be more structured than that. And then important to understand with consent is your conduct cannot exceed the consent given. If the consent is given to do procedures A and B, and when you are busy with the treatment of the patient, you then decide to do a procedure C or D, that falls outside of the consent, and you may quite well find yourself in a position where the patient takes exception to what you've done, and that could, as you'll see in subsequent slides, be regarded by the courts as assault on that patient. So understand that when we look at informed consent, the Constitution, our South African Constitution, in the Bill of Rights, speaks to the security in and control of one's body. So under Section 12 of the Bill of Rights, everyone has the right to, amongst other things, being free from all forms of violence, from either a public or private source, and they have the right to bodily and psychological integrity, which includes the right to security in and control of their body. Now, when we look at that in terms of our practices, when we start talking about everyone has the right to be free from all forms of violence, any physical act that you do as a practitioner to a patient without their consent can be considered to be an infringement of their Section 12(1)(c) rights to be free from all forms of violence. It would also violate their Section 12(2)(b) rights in terms of their bodily and psychological integrity, which means that when you do an act without their consent, they are not in control of the security in and control of their body, and you have then violated their constitutional rights. Now, I use this as the segue because consent is important, and our respect of each other's bodily integrity is important. And I think sometimes, because of the therapeutic privilege, we don't always have the deeper, broader understanding of our responsibilities as a practitioner and the rights of the patient in terms of their own expectations. The difficulty that we have is under the errors of commission and the errors by omission. Your risk is that by doing something without consent, you are perpetrating an error by commission. By not providing subsequent or enough information, you are creating an error by omission. And so both of those play a role in terms of informed consent, in terms of the Constitution. In terms of our National Health Act, Section 6 of our National Health Act says the user has to have full knowledge. So you, as the healthcare provider, must inform the user. In other words, the patient, or in the form, if there's a child, the patient and the guardian or parent, and if there is somebody of limited capacity, that individual plus the parent or their custodian or their caregiver or their guardian, you need to inform the user of their health status. And you need to do that with the rare exception, but an exception of circumstances where there's substantial evidence that in disclosing that health status would be contrary to the best interest of the user. You also have to recognize that the user has the right to refuse health services, and you need to explain implications and risks to them. So in terms of giving over information for informed consent under Section 6.2 of the National Health Act, you as the healthcare provider must inform the user in a language that the user understands and in a manner that considers the user's level of literacy. And that may require that you use pictures, videos, draw diagrams, and translate what your understanding of the physiological and physical and psychological implications might be in a manner that is accessible and understandable to that patient. So you've got to give over information, and it requires their getting knowledge of and developing appreciation of the procedure of, firstly, what's wrong with them, their condition, and secondly, what you're going to do with them. And appreciation, as defined, is the act of recognizing or understanding something that is valuable, that is important, and as it is described. So the question that you might ask yourself at this point in terms of the process of consent that you give is, does the person get the knowledge that is required, and do they appreciate the impact of that knowledge on their life in a manner that they can understand and in a manner that they can describe to other people? So that would be your first steps in understanding informed consent. The National Health Act goes slightly forward there, and it also says that consent of the user must be obtained unless, and it gives certain reasons why we wouldn't get informed consent. If the user is unable to give informed consent, and consent is given by a person mandated in writing or authorized by law. So a person may give an advance directive. The person may not be in a position to give consent because they are unconscious. Now, if that is the case, the consent can be given in order by a spouse or partner, then by a parent, then by a grandparent, then by an adult child, then by a brother or a sister of the user, but in that order. So one has to bear in mind that where the user is unable to give consent, you need to be able to seek consent first from a family member who is mandated to do so. Secondly, if you can't get consent from the patient and you can't get consent from the immediate family in that order as described, you could then get consent from any law or a court order. Now, the difficulty to do that is you need to petition the court for that. There is a process for that, and it does happen in exceptional circumstances. Then you've got two further complications. The first is that you, in an event that the patient cannot give consent, may treat that patient if the failure to treat them will result in a serious risk to public health. Now, you would have to decide and define what a serious risk to public health would be, and usually that's well defined in terms of communicable diseases. So we're in a pandemic right now where the Disaster Management Act and its related regulation are quite specific about our responsibilities and obligations as a practitioner and the obligations and responsibilities of the patient. So if there is a failure to treat the user that will result in a public health risk, you're obligated to treat that patient even without their consent. Equally, you are obligated to treat the patient without their consent if you're unable to receive it, if any delay may result in death or irreversible damage to their health. Now, you've got to make a very determined clinical decision in terms of Section 7(1)(d) and E, and there you're going to need to be able to lean on your colleagues to make those decisions and practically, probably, preferably, deal with the patient's families or authorized persons first. It would be a difficult decision for one to make in one's private practice. But if one is on the side of the road, or there is a Good Samaritan Act required, or there is a urgent triage required, one may find oneself in the position where one has to make those decisions. That being said, you would need to then answer that in terms of Section 7.2, that you've taken all reasonable steps to obtain the user's informed consent prior to embarking on any treatment regime. Because, as Section 7.3 says, informed consent means consent for the provision of a specified health service given by a person with the legal capacity to do so and has been informed, as contemplated in the slide before, in terms of what they need to do, what they need to understand, and how they need to understand it, with the knowledge and appreciation that needs to be done. So you can see here that you always need to give informed consent, except in the time and in a crisis situation where consent can be received from a third party appropriate, or where there will be a significant impact to public health or death or irreversible damage. Now, once we get into that, there's a whole different journey. Today's presentation isn't to talk about the journey of procuring consent in areas where the patient can't give it. It's rather to let you know that there are times that and provisions made that you can't always receive consent. So I bring you now into a little bit of case study to give you a sense of reference. In the first case in Stockberg versus Elliott, which was in 1923, any bodily interference with our restraint of a person is not justified, and if it's not consented to, is wrong. Now, that came out and was followed immediately by part of the same judgment that says it's as important to record what you did as it is to what you did. So not only is exercising a treatment on a patient without their permission considered to be assault or an injury to that person, how you record what you did is as important as what you did. Now, the locus classicus case, which is what we would refer to as the case that positioned this argument, came out in Castile versus De Geef in 1994. And there, some of the statements, amongst others, were that the doctor's duty to disclose a material risk must be seen in the contractual setting of an unimpeachable consent to the operation and its sequelae. What that means is that you have a contractual obligation as the practitioner with your patient that you cannot get out of, that you need consent from that patient to do the operation, and that the patient has to understand the consequence of the operation and the outcomes of that operation and your intervention. Your failure as a physician to adequately inform the patient constitutes assault and not negligence. So not only could you be negligent for having done something without due consideration, but if you don't address the patient's rights in terms of their Bill of Rights, in terms of Section 6 and 7 of the National Health Act, you are then perpetrating assault, which is a criminal issue, in addition to negligence, which is a civil issue. And you, as the doctor, has a duty to warn the patient of the material risks inherent to a proposed treatment. This duty is subject to therapeutic privilege between yourself and your patients, but please understand that it is there. You will see on the right-hand side, failure to disclose the risks may render you liable to an action of assault. But you may frighten the patient by disclosing too many risks. So you have to show that there is a balance between what you informing, what the patient can understand, and what needs to be done. So what degree of risk should be disclosed to a patient? The Health Professions Council said any risk that has the reasonable outcome of creating an adverse outcome. So any risk to the patient where a complication and adverse outcome may arise, you need to share with them. So if you don't have informed consent, a violation of the plaintiff's right to bodily integrity occurs. You have actually stopped them being able to make decisions about their body that they have every right to do. So I keep those in mind for you so that you can appreciate that consent has an importance not only in terms of whether you're doing good clinical care. You can do good clinical care and through not informing your patient of what you're doing, create an environment where it could be considered to be assault. And whilst we work in a beneficent profession where we want to look after our patients and we want to provide the best care, the moral hazard exists that providing the best care without informing them could lead to a negative situation for yourself. So we talk about informed consent. Chapter 9 of the Mental Health Care Act of 2002 says that you need to secure consent to care, treatment, and rehabilitation. Now, we we're talking largely here about able-bodied persons, but for those of you that do treat persons who would fall under the Mental Health Care Act, it's important to know that the provider or health establishment may provide care, treatment, or rehabilitation services only if the user has consented to care or treatment or rehabilitative services or admission, or if the above treatment or rehabilitative services or admission has been authorized by a court order or a review board, or where, because of the mental illness, a delay in providing care may result in death or irreversible harm to the user, or may result in the user inflicting harm on themselves or others, or may result in the user causing harm to or serious damage to property belonging to them or others. So you've got some tests that you can apply. And again, I would ask you if you have, in terms of providing access to care, if you have these checklists in place. Now, I'm a big fan of an author called Atul Gawande. And Atul Gawande, as a general surgeon for the World Health Organization, did a series of reviews looking at the causes of poor outcomes. And the summary of what he found, and he then reported in a book called Checklist Manifesto, and then amplified in a book called Better, is that we often leave out a step or steps in a process of care. So my recommendation to you is, if you read Atul Gawande's books, Checklist Manifesto and Better, you should also read his book called Complications, which is his third book, which says, despite the fact of knowing what we should do, we don't always exercise discipline in doing what we know we should do. So you should have, for informed consent, a checklist that you follow to make sure that you are providing both minors and adults and persons who are users under the Mental Health Act appropriate information for them to have the knowledge to make the decisions around the integrity of their body. So in terms of the ethical rules, in terms of Booklet 2, Section 27A, there are significant responsibilities in terms of the health practitioner. The first is that you need to respect patient confidentiality, privacy, choices, and dignity. Now, those are big words, and patient confidentiality and privacy are different things. So what you share about a patient's information and how you keep the patient and their information private need their own criteria to be met. How you manage their choices and treat them with dignity and respect includes the manner in which you communicate with them. It includes the manner in which you engage and preserve the information that they share with you. It includes the manner in which you provide care. So part of that then says, you as a practitioner under Section 27A need to provide adequate information about their diagnosis, their treatment options and alternatives, and the costs associated with each alternative. You also need to share with them what other options and alternatives they may have, so that they can exercise their choice in terms of treatment and informed decision making. Now, you need to be able to make provision in your patient consultation time for this conversation to happen. You'll recall earlier on in the presentation, I put the graphic up there with the practitioner and the patient standing, with all of the different treatment options, with the benefits, with the risks. It's complex to be able to provide this. So part of what you need to do in terms of supporting patients' choices and dignity is provide that information in an infographic and content-rich way that they can make that information. And then under Section 27 AG, you need to, except in an emergency, obtain this consent. And when you cannot obtain it from the patient, obtain it from the appropriate person or their next of kin. So there are 4 golden rules that were written by Strauss in 1990, which I think are still very pertinent and relevant for us today. The first is, one needs to obtain consent from the person legally competent to give that consent. One needs to obtain an informed consent, because an consent that is not informed is not an appropriate consent. That consent needs to be clear and it needs to be unequivocal. In other words, there needs to be no ambiguity around that consent, and it needs to be comprehensive. you may need to get consent for 2 or 3 different procedures, and a different consent for finance, and a different consent for the general rules and management of your practice. But make sure that the consent that you get is appropriate for what you do. So you'll see on the left-hand side there, I've said that the main responsibility of the health practitioners is respect, respect, respect. There's respect for your patient, there's respect for the information, and there's respect for yourself. Each of those needs to happen within the ethical rules and guidelines. Why respect for the patient? Because the patient has put their trust into you. Respect for yourself in terms of your practice, because your practice is a freestanding output that you're giving. Your practice has its own reputation, it has its own responsibilities, and it has its own obligations. And you as a practitioner need respect for yourself, because if you are not following all the guidelines that you need to be doing, it is yourself, your name, your reputation, and your years of practice and experience that come under question and scrutiny. So informed consent is a delicate, multifaceted journey. Now let's pause for a second and move away from informed consent and spend a little bit of time reflecting on what is a medical record. So we've spoken first about the fact that you need consent, and that consent needs to be recorded. But it needs to be recorded, and you'll see, and I refer you to booklet 9 of the Health Professions Council in terms of the keeping of records. They define a health record as any relevant record made by a healthcare practitioner at the time of or subsequent to a consultation and or examination of or the application of health management. So that record can be made at multiple times. Now that health record needs to be constituted in a very specific way. It needs to contain the information about the health of an identifiable individual, recorded by yourself as the healthcare professional, either personally or at your direction. So an example would be, you may dictate your record or record your record and instruct another person to transcribe that record. But they can't transcribe a record if you haven't given them specific instruction to do so. So you may consider a record in terms of a number of different things, but let's just talk about it in terms of how the Health Professions Council booklet 9 reviews a record in terms of section 2. They regard a record to be handwritten contemporaneous notes taken by the healthcare practitioner. Now, at this point, I would challenge you, and I tell a joke, and some of you may have and may well hear it in the future, of how one gets into medical school. And it's that you write a handwritten application, and if your handwriting is legible, you are not eligible for medical school, and if your handwriting is illegible, you're invited to come in. And I say that tongue in cheek because, having read notes of my own over years and having read notes of colleagues, we write particularly badly, and sometimes we even regard it as a badge of honor. But your handwritten contemporaneous notes must be legible. And they must not only be legible to you, they must be legible to other practitioners. And not only other medical practitioners, you may need to be providing your healthcare notes to an attorney or a mediator or a third party who would be reviewing these to defend you in your absence, or to defend you in a manner with your presence. But if your notes are illegible, you cannot use them. Your health record also includes notes taken by previous practitioners attending healthcare or other healthcare practitioners. Typed discharge summaries are part of the health records. Referral letters to and from other healthcare practitioners are part of the health record. Laboratory records and other laboratory evidence, histology sections, histology slides, printouts from automated analyzers, X-ray films, MRIs, ultrasounds, ECG traces, all are included and are needed to be considered in terms of your health record. So when you are doing laboratory or other tests, you need to make sure that your health records, when you have a report, includes the patient's name, includes the time and date, and includes all the relevant information, so that it can be integrated. You also need to include that all audiovisual records, including photographs, videos, and tape recordings, need to be included. Currently, and as we move forward, digital recordings would be included in your records. So digital recording could be the recording that you make using a mobile phone or a smart device, or a telemedicine consultation where you record on WhatsApp or on Skype or on Zoom or on any one of a number of other platforms. You need to bear in mind that all of those records would be considered to be part of the health record. If you're doing research, clinical research forms and clinical trial information and data is included. All insurance forms, all disability assessment, and all documentation of injury on duty would be regarded as a health record. Death certificates and autopsy reports are also regarded as health records. So at this point, I would challenge you to go back and ask yourself the question and say, how much of what we're doing right now in our practices are or fall into what would be defined as a health record? A question I would also ask you at this point is, how many of you are running your health record as electronic medical records? I've got colleagues who I've worked with who've been in practice. I started my first health record in 1996. So we go back 24 years. I now do all my records using an electronic record system. And I talk to some colleagues and they say, you will have to pry my pen from my cold, dead fingers before I stop making handwritten contemporaneous notes. That's fine, but you've got to store those notes. And you've got to store those notes depending, and we'll come into this now, for periods of time which are important. So when we start looking at the ethical rules, section 3, in terms of documents and materials, why do we need to keep these documents? We need to keep them to further the diagnosis or ongoing clinical management of the patient. Well, that goes without saying, but it's important to raise this up. We need to keep our clinical notes and documents and health records to conduct clinical audits. Now, a question I might ask you at this point is, do you conduct clinical audits of your own practice? In institutions and in certain circumstances, the records are there to promote teaching, research. They're to be used for your and other persons' administrative and other purposes. A point that we raised earlier, and it is an unfortunate reality, but it is a reality. Your records need to be kept as a direct evidence in litigation. Equally, for occupational injury and disease compensation purposes, your record may be requested by a third party to be reviewed, either for a dispute, for litigation, or because of an occupational injury or compensation case, or for a road accident claim. It may be used for research data. You also need to keep these for historical purposes. In many cases, a record is used to promote good clinical and laboratory practices, and that goes back up to promote teaching and research and learning. Your documents are there to make case review possible, and sometimes, just like with other CPD, to serve as a basis of accreditation. It's important under Rule 15 to recognize that any student or intern or practitioner in the execution of their professional duties, anyone who signs official documents relating to patient care, such as prescriptions or certificates or patient records or hospital other records, must do so with their initials and surname in block letters. You also need to do that in pen. And any alterations you make in your records need to be permanent alterations, and they need to be explained and justified. So as we go into that, which is then section 4, the information that you need to keep, whether it's on a electronic basis or on a handwritten contemporaneous basis, needs to include, at the very least, these 12 components. It needs to include the patient's identifying particulars. Now, that includes age, race, gender, location where you saw them, any particular identifiers that are specific to their health condition. Your biopsychosocial history of the patient, including allergies, idiosyncrasies, medications used, and we'll come down to that a little later. You need to be including the time, the date, and the place of every consultation. So in my case, where I've got an electronic record system, every time I enter notes, the system captures the time and the date and the place of my notes. So if I'm making alterations, and we'll talk about that, it's contained on the left-hand side of the screen, any alterations that you make to your record need to include time, date, and place. You need to include your assessment of your patient's condition, the proposed clinical management, and the medication and doses prescribed. Now, in prescribed clinical management and medication and dosage, you also need to include your rationale of why you want to use that medicine for that clinical condition. If you are doing referrals to specialists, you need to include not only the specialist that you're referring to, but the notes on the referral that you're doing. You also need to include the patient's reactions to treatments or medication. Now, the question I would ask you at this stage is, how would you know the patient's reactions to treatments and medications, including the adverse outcomes? You would know that if you've got a checklist that includes safe medicine practice and safe post-treatment practice, where you are following up with that patient on defined periods of time. And I want to give you an example of this on a case that came to me recently, where the patient had an inguinal procedure for what was potentially going to be the repair of an inguinal hernia and the installation of a mesh to repair the hernia. Patient woke up the next day and was told, you didn't have mesh installed. Actually, what it was an infection, and we cleaned out the infection and everything is fine. Now, the patient was furious about this, and because of the way that the escalation happened, it landed on my desk really early, and I got to say to the patient, well, have you chatted to your surgeon yet? The patient said, no, I haven't seen the surgeon since the procedure was done. And I said to the patient, well, when are you supposed to be seeing the surgeon to have a follow-up with this? And the patient said, well, only in 2 days' time. I said to the patient, well, when you found out that this was an infection and not a need for a surgical repair, and you were anxious, did you call the practitioner? And the person said, no, but I'm calling my lawyer first because I'm really angry. And the dialogue that came out of this, and the reason that I'm sharing the story, is the patient's reaction to the treatment and your expected outcome may be quite different. And your mechanism for following up early rather than later may need to be a structured strategy that's recorded in your records. So bear that in mind and use that as a self-reflection to say, do you have a scheduled follow-up with each person post-treatment? And if you've put them on a medication regime, if you've introduced a new medication to them, have you made a note to follow up with them in 1 or 2 days to understand whether there are adverse outcomes or side effects? Then you need to record in your records test results. And as I said to you earlier, you need to annotate those test results to make sure that they don't get separated or lost. All your imaging investigation, part of test results. If there was a time where you medically boarded this patient or booked them off reasons from work or issued a certificate of indisposition or a medical certificate, you need to record that. And where applicable, in other words, in all cases where you're going to do a procedure, you need to have written proof of informed consent, both general consent and procedural consent. Now, bear in mind as we go through this, that no information or entry may be removed from a health record. If you have an error or you made an incorrect entry that was discovered, this may be corrected. And the recommended way of correcting it is placing a line through it with ink and correcting, not using correcting fluid and blanking it out. When you correct it, you need to include the date of the change, and the correction must be signed in full, and the original record must remain intact and fully legible. Additional entries that you add at a later date must also be dated and signed, and the reason for the amendment or the error needs to be specified on the record. Part of that is because you may not remember in a week, a month, a year, or 3 or 5 years from now why you made the correction, and that error is a permanent, that amendment or that error and that error are regarded as part of your permanent history. So bear in mind that amendments to records are important and your completeness of records are important. So how long do we need to retain records for? So health records need to be retained for at least 6 years from the date that your treatment with that patient becomes dormant. Now that's for a person in the majority, in other words, a person of who's legally competent over the age of 18. In the case of minors, that record needs to be kept until they become a major, in other words, until they reach the age of 18 and until the minor's 21st birthday, because there is the position where a minor, when they reach 18, can seek redress in their own right, and there's a 3-year prescription. So you need to keep the record for the minor until their 21st birthday. For a person who is mentally incompetent, for whatever the reason is, you need to keep that record for the duration of the patient's lifetime. And equally, in terms of occupational health and safety, you need to keep those records until the patient is has passed a 20 years post-treatment period. So you have a duty of recording and keeping records for a significant amount of time. Now, where do you keep those records? They need to be stored in a safe place. If they're in an electronic format, they need to be safeguarded, preferably in the least with password and in the best with two-step authentication, so that third parties cannot have access to passwords and they cannot have access to those electronic records. And I'll give you an example of this. You may keep your records on your desktop or your laptop, and then you may get an IT company to come and do work for you, and you give them the password, and now they've got access to all of your cloud storage. That IT practitioner now has access to your patient records, and you're now potentially in breach of your confidential obligations with your patient. So please be sure that you satisfy yourself and understand the guidelines with regards to the retention of patient records on, at that stage, they were called computer compact discs, but it would be on any hard drive or on any cloud storage device. If you work in a hospital, records kept in a provincial hospital clinic can only be destroyed as authorized by the Deputy Director General concerned. So bear in mind that retaining records in our world right now is paper-based and or electronic-based. And if it is electronic-based, you need to be very careful around your preservation of records in terms now of POPI, which is the Protection of Personal Information Act, which was promulgated in 2013 and came into full effect on the 1st of July 2020. In other words, 3 weeks ago as of the recording of this. So who has access to your records? Under Section 11, in terms of the Health Professions Council Ethical Guideline, a healthcare practitioner shall provide any person of the age of 12 and older with a copy or abstract or direct access to their records regarding medical treatment on request. This is also consistent with the Children's Act. So you need to be able to have these records available to a 12-year-old or older. Now you can provide them with a copy of the records. You can provide them with a summary or an abstract or direct access depending on the sort of record keeping systems you use. Where the patient is under the age of 16, the parent or legal guardian can make the application for access to the records, but the patient has to give you written consent in addition. And that's under the Access to Informations Act, which is Act number 2 of 2000. Information around the termination of a pregnancy may not be divulged to any party except the patient themselves, regardless of the age of the patient. The patient has the exclusive and sole rights to manage their information around their termination of their pregnancy. And that's in terms of the Choice of Termination of Pregnancy Act, number 92 of 1996. Now, no healthcare practitioner shall make any information available to any third party without the written authorization of a patient or a court order, or where non-disclosure of the information would represent a serious threat to public health. We discussed that in terms of Section 6 of the Act. Now, one of the things that one needs to be mindful of is the inadvertent sharing of information that could be caused by conversation or by the use of a shared information where you are doing a case study where the patient's information could be intuited or the patient's identity could be identified. So a checklist for you as we begin to wrap this up. Your records should be complete, but they should also be concise. You don't have to take a narrative record of several pages. Your record should be consistent. And a recommendation or an observation here, and you'll see it coming down, is that you should be using a standardized format where possible, so that you don't leave out any component of the case history. You should avoid writing self-serving or disapproving comments in a patient record. And you should avoid making social or disparaging comments about your patient unless they are clinically appropriate comments that are part of your diagnostic interpretation. The checklist: if any record needs alteration in the interest of patient care, a line in ink should be put through the original entry, but that original entry should still remain legible. The alteration should still be signed in full and dated, and where possible, the new note should refer to the correction without you altering the original entry. Copies of records, as discussed in the previous slide, should only be released after receiving proper authorization. Billing records should be kept separate from your patient care records, and all attached documents should always be labeled. This is important because it's not difficult for documents to go wayward, and you need to make sure that all of your documents are concise and present. So let's just pause at this point and reflect. We've spoken about informed consent. We've spoken about record keeping. Now, informed consent is important so that your patient and you have taken the time for them to have a full understanding of the implications of the treatment. The record keeping is to show that diligence was done in terms of that record keeping. Now we talk about the disclosure, which is the sharing of that information with other parties. And that relates to and is referred to in booklet 5 of the Health Professions Council Ethical Guidelines, under the booklet which is Confidentiality, Protecting and Providing Information. So here we're aware that when a healthcare provider is satisfied that information should be released, and that would be with the in-writing consent to release that information, he or she should act promptly to disclose all relevant information. And there the key words are relevant information. There may be information that shouldn't be shared, and you need to do this in the best interest of the patient and to safeguard the well-being of the patient and of others. So patients have that right to expect that information about them will be held in confidence. You need to make sure that improper disclosures are limited. And improper disclosure could happen on social media, could happen in corridor talk. If you're sharing on a social media site with other clinicians, you need to understand that there is the risk that even if you delete something, that somebody else may have captured that information and stored it prior to you deleting it. There's a consensus right now that once information has hit a broad base of users on the internet, or it's been digitized and shared, it's almost impossible to control the spread of that information. Where you are going to be sharing information in a therapeutic or educational environment, or between practitioners to provide transition and continuity of care, you also need to make sure that the patients are aware that their personal information will be shared within the healthcare team. They need to be explained why. They need to be explained what the impacts and the risks were. Now, this goes into what we discussed earlier, which is the meaningful consent. So when you're sharing information, that principle of who will get the information, what information will they get, where will this information be shared, when will it be shared, why will it be shared, and how will it be shared, needs to take center stage in how you work with the patients. Seeking their consent to disclosure, it's part of good communication between yourself as a healthcare practitioner and the patient. There will be situations where you have the contractual obligation to third parties, as well as your obligation to the patient. And one of those examples may be with a medical scheme who you are contracted in with and the patient is contracted in with, where the medical scheme requires information regarding your patient, and the patient needs to consent to the sharing of that information formally and expressly and in writing, so that there is no confusion that you will be sharing information with that party when required contractually to do so. And then understand that disclosure in public interest is important. So in all cases where you need to disclose in the public interest, you must weigh the possible harm to the patient against the benefits that to the public that will be likely arising from the sharing of this information. It's always a tightrope that you need to walk. It's never a case of disclosing an indiscriminate amount of information. So I hope that's been a useful journey for you. I'm handing you back to Michael John from Genoa.
Thank you, Brad, once again for an incredibly informative talk and address. I'm sure I speak for all of the practitioners that have taken the time to listen to it, that the information contained in there is incredibly useful. Genoa Underwriting Managers is incredibly passionate about CPD education for our insureds and for the industry as a whole. And this talk in particular assists practitioners with risk mitigation within their practice. For those of you who would like to find out more, please will you follow us on our LinkedIn platforms, as well as our YouTube platform, which is come up on the screen for you now. And that'll just allow you to stay informed in terms of additional talks and CPD activities that we'll be doing in the future. Thank you, and we hope that you enjoyed this talk. Enjoy the rest of your day. Ciao.
Here we go.
All right, fantastic. Do you mind if I just quickly redo the first one?
Yep.
The intro. Yeah, just because, and we'll just see. Brad, thanks very much. It was good, as always.
Happy? Are you happy?
Absolutely, I was, sir. You nailed it.
Okay, cool. So those are the hardest ones done, and we now get to the easier, more fun ones.
Superb. I'm just going to redo the introduction. I'm going to try and free flow it a little bit more and less sort of straight, and then Nicola can choose which is the better one of the two. But if you don't mind popping the text on the screen for me, and then you tell me when you're ready.
Perfect. Just a question before you start, MJ.
Yeah.
Nicola, from yourself and guys from your side, is there anything that you want me to keep in my mind to do differently for tomorrow so that I can prepare differently, other than to bring some bourbon with?
Delivery-wise from my side, I think it's very clear.
Perfect. Brad, so this one was 100%. Like, there were no internet glitches, there was nothing. So I think you nailed it, eh?
Oh, good. Okay, fantastic. MJ, thanks. And we might talk later. Otherwise, I'll catch up with you.
Thanks very much, Brad. Much appreciated, eh?
Thanks, guys. I'm going to click the leave the studio. Is that right?
Perfect.
Yep.
Thank you. Okay, so you want to do intro 1?
Let's do intro 2 again, which is for this session. Do you think we should do 1 as well, or?
I didn't mind it at all. I thought your intro.
Do you think it was fine?
Yeah, I think it was fine. I'm going to do this. So I
Okay.
see your outline. So the general consensus for this kind of stuff is the less. I say that will be too small for you to read, right?
Yeah. So the less. So I'll just try and not move my head like this, and I'll just keep the head straight.
Yeah. So let me see.
What I'm going to do as well is I'm just going to.
Closer to camera, if you can still see that. That's good.
And he's just talked on informed consent. Okay, so yeah, I'm going to try and not read that. I'm just going to try and free flow it, but you can leave it there. That's perfect. And I'll just pick up some points as we go. You tell me when you're ready. Good day, doctors. First off, thank you so much for taking some time out of your busy schedules to join Genoa Underwriting Managers for another one of our CPD events. My name is Michael John Demant. I'm a director of Genoa Underwriting Managers, and we are a professional indemnity insurance expert who focuses on the needs of professionals like yourselves. We've built up a proven track record as we take care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course have a sizable pool of select medical practitioners that include some of you in the room today. I have the pleasure in introducing Dr. Brad Byra, who will be discussing informed consent with us. Brad is an accomplished speaker who has spoken around the world on various medico-legal topics, and he is a great asset to the Genoa team. Please enjoy the presentation, and with that said, over to you, Brad.
Let's go for one more, just a little bit looser now, a little bit of a smile.
Okay. All right.
Whenever you're ready.
Good day, doctors. Thanks very much for taking the time to join Genoa Underwriting Managers for another of our CPD events. Genoa, as many of you will know, is not your typical insurer in that we don't focus entirely on offering insurance to, sorry, I've got to start that again.
Start it again. No problem.
Good day, doctors. Thank you for taking the time out of your busy schedule to join Genoa Underwriting Managers for another one of our CPD events. My name is Michael John Demant, and I'm a director of Genoa Underwriting Managers. Genoa is not your typical insurer in that we focus entirely on offering professional indemnity insurance solutions to the professional market. Our management team has been doing this for decades, and we would be regarded as experts in the field. We've built up a proven track record as we take care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course, the sizable pool of select medical practitioners that include some of you in the room today. I have the pleasure of introducing Dr. Brad Byra, who will be discussing informed consent. Brad is an accomplished speaker who has spoken all around the world on medico-legal topics, and he is a true asset to the Genoa team. Enjoy the presentation, and with that said, over to you, Brad.
That sounds very good. I think you're worrying too much about your delivery.
Reckon.
About what you know, you're worrying about the hand movements.
Okay, so I should stop doing that.
Don't even worry about it. You know what I mean? Just deliver the way you would normally say it, like if you were just telling me or just telling anybody like that.
Okay,
because
cool.
I can feel now you're going like, as you go, oh shit, I should have moved my hand there.
Yeah.
Then you're like, okay, oh shit. You know, that's cool.
Can you move it up slightly for me? Just like, yeah, okay, that's 100%. Is my eye line in? You happy with that?
Yeah.
Okay.
Okay. And you can go for it.
Good day, doctors. Thank you so much for taking the time to join us for another one of the Genoa Underwriting Managers CPD events. Genoa is not your typical insurer in that we do not focus on things like your house. Oh, fuck. Okay, let's go again. Fuck's sakes. Good day, doctors. Thank you for taking the time out of your busy schedule to join us. Oh, fuck me. Now I'm overthinking this crap.
Yeah,
okay.
That's like a little intro, man. Don't
Yeah.
about it.
Okay. Good day, doctors. Thanks so much for taking the time out of your busy schedule to join Genoa Underwriting Managers for another one of our CPD events. Genoa is not your typical insurer in that we only focus on professional indemnity insurance for professionals like yourselves. We've been doing this for decades and would be regarded as experts in our field. Over the years, we've built up a proven track record where we take care of the needs of, in addition to, oh, fuck me. Sorry.
It's okay. You want a water yet?
No, I'm good. Okay, let's go one last time. Okay. Good day, doctors. Thank you for taking the time out of your busy schedule to join us today for another one of Genoa Underwriting Managers CPD presentations. My name is Michael John Demant, and I'm a director of Genoa Underwriting Managers. Genoa, as many of you in the room will know, is not your typical insurer in that we only focus on professional indemnity insurance for professionals like yourselves. We've been doing this for decades and are regarded as experts in the field. Over the years, we've built up a proven track record where we take care of the insurance needs of in excess of 4,000 attorneys, the top business rescue practitioners in the country, as well as, of course, a sizable pool of select medical practitioners that will include some of you in the room. I have the pleasure today of introducing Dr. Brad Byra, who will be discussing informed consent with us. Dr. Byra is an accomplished speaker who has spoken all around the world on medico-legal matters, and we're very proud to have him as part of the Genoa team. Please enjoy the presentation, and with that said, over to you, Brad.
That one was very, very nice. One or two little bloopsies.
Okay.
But let's go for one more.
One more.
Because what we can do is we can like piece together pieces and maybe crop in a bit tighter into one answer.
Alrighty.
Okay, this is the one.
Good day, doctors. Thank you for taking the time out of your busy schedules to join Genoa Underwriting Managers for another one of our CPD events. My name is Michael John Demant, and I'm a director of Genoa Underwriting. Genoa is not your typical insurer in that we focus entirely on offering professional indemnity and solutions for professionals like yourselves. Our management team has been doing this for decades and are recognized as experts in our field. Over the years, we built up a proven track record where we take care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course, have a sizable pool of select medical practitioners that will include some of you here today. I have the pleasure of introducing Dr. Byra, who will be discussing informed consent with us. Dr. Byra is an accomplished speaker who has spoken all around the world on medico-legal matters, and we're very proud to have him as part of the Genoa team. With that said, please enjoy the presentation, and I hand over to you, Brad.
Okay, perfect. One of the good things is this one you didn't say some of you in the room.
Ah,
Because,
okay.
Let's do
Last one.
Yeah, last one. That one was very, very nice.
Okay.
So what I noticed is you stutter a little bit when you're not following script.
Yeah.
When you got a little bit of script. So don't stress too much.
So can you see I'm reading it or?
I can't really see. I'm trying to look at your eyes as clearly as possible on the screen. I can't really
Okay.
see.
So then let me stick to the thing there.
Go for it.
Good day, doctors. First off, thank you for taking the time out of your busy schedule to join the Genoa Underwriting CPD event. Let me start again. Good day, doctors. Thank you for taking the time out of your busy schedules to join Genoa Underwriting Managers for another one of our CPD events. My name is Michael John Demant, and I'm a director at Genoa. Genoa is not your typical insurer in that we focus on offering professional indemnity insurance solutions to the professional market. Our management team has been doing this for decades and is recognized as experts in the field. We've built up a proven track record as we take care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course, have a sizable pool of select medical practitioners that include some of you here today. I have the pleasure of introducing Dr. Brad Byra, who will be discussing informed consent. Dr. Byra is an accomplished speaker who's spoken all around the world on medico-legal matters, and we're very proud to have him on the Genoa team. Please enjoy the presentation, and with that said, over to you, Brad.
Cool. Can we do that middle section we have built?
Yeah, sure.
Up until some of you. Just make sure you finish on some of you and not here today or in this room or anything like that. Okay.
Over the years, we've built up a proven track record as we have taken care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course, have a sizable pool of select medical practitioners that include some of you.
Very cool. Can we do last one from the top now?
Okay.
And then I've got everything, I think.
Good day, doctors. Thank you for taking the time out of your busy schedule to join this Genoa Underwriting Managers CPD event. My name is Michael John Demant, and I'm a director of Genoa. Genoa is not your typical insurer in that we focus entirely on offering professional indemnity insurance solutions to the professional market. Our management team has been doing this for decades, and we are regarded as experts in our field. We've built up a proven track record over the years, and we take care of the insurance needs of over 4,000 attorneys, the top business rescue practitioners in the country, and of course, have a sizable pool of select medical practitioners that include some of you. I have the pleasure of introducing Dr. Brad Byra, who will be discussing informed consent. Dr. Byra is an accomplished speaker who has spoken all around the world on medico-legal matters, and we are incredibly proud to have him as part of the Genoa team. Please enjoy the presentation, and with that said, over to you, Brad.
100%.
Better?
Yeah.
Sorry, I panicked here.
No problem. Nicola, do you want to unmute your mic there and you can... There we go. Can you hear us, Nicola?
Yeah. Can you
Nicola,
hear me?
We can now. You were sort of coming and going in the beginning.
Oh, okay, cool. No, I think we've got enough takes now to make sure that the guys, can get it right. I think it came across a lot. You're getting better and better, MJ.
Okay.
But tomorrow you'll be a superstar.
Do you
I think it all went well.
Do you need me to redo the first one?
Mornay, is there a way I can see the first one, the final version, because I'm not getting tea.
Say that again, sorry, Nicola.
She said, is there a way she can see the first one?
Not over the line, but I can send it to her.
So,
Sorry, I missed the final.
I think maybe let's just
I'm
do,
sure it's
if you
fine
don't
though.
mind, let's just do one or two of the first one, just so that we have it. Now I've got to change, unfortunately, because I'm wearing this. I was wearing that when we did the other one.
No problem. Let's just
Yeah.
So Nicola, we'll just do the first one just in case, so that we've got it 100% just while I'm here.
Yeah, absolutely. I'd rather we got it right and you didn't have to go and redo it all again on Friday, say, for instance. Yeah.
Joe, we'll sort that out.
Sorry.
No problem. Just gonna change tops. Just wardrobe change. There you go. Okay. Plug this little bad boy back in. Thank you. Oh, sorry, it's not on. We can deal with that guck again. There we go. Shut. Cool.
Okay, I'm going to mute myself now. Okay.
Okay,
Yeah, I think
100%.
MJ. I think the only thing is just remember not to say in the room or this evening kind of thing.
Okay. Perfect.
Okay, there we go.
Tell me when you're ready.
And ready.
Good day, and welcome to another of the Genoa Underwriting Managers CPD series. My name is Michael John Demant, and I'm one of the founders of the company. Genoa, as many of you will know, is a liability insurer with a long history in the professional indemnity space. We're not a typical insurer in that we don't insure your car or your house, and instead we are specifically focused on insuring professionals like yourselves. The Genoa team has been offering professional indemnity solutions for many years and is regarded as experts in the space. I have the pleasure of introducing Dr. Brad Byra, who will be focusing on medication errors. Over to you, Brad. Okay. Nicola, were you happy with that one? Hopefully. So you're good with that one, and we don't need to do another. Cool.
Nicola, you there you go.
Yeah, it's perfect.
Okay.
Yeah, perfect.
Great. Thanks, guys. Sorry
Thanks,
about that.
guys.
Not used to this kind of stuff. I find it quite intimidating.
Okay, thank you, Nicola.
Thanks, guys. I'll see you tomorrow.
Yep.
Yeah, we're just busy trying to do those intro slides.